Welcome, everyone. Welcome to this webinar hosted by Organic Farmers Association. My name is Allie Lynn, and I am the Membership and Outreach Coordinator for OFA. The mission of Organic Farmers Association is to provide a strong and unified national voice for domestic certified organic producers. OFA aims to build and support a farmer-led national organic farmer movement and national policy platform. Today, we're excited to have David Runsten, Policy Director of Community Alliance with Family Farmers, to speak on how immigration reform affects organic farmers. Immigrants have been critical to meeting the agricultural demand. In this webinar, David will be giving updates on immigration reforms, such as the H-2A temporary agricultural program for guest workers and the way they affect organic farming. David directs all of Community Alliance with Family Farmers policy work, as well as food and safety and water stewardship outreach. Dave is an agricultural economist who conducted research on topics such as contract agriculture in Mexico, and regional competitiveness of the produce industry, living wages in Los Angeles, and farm labor in California. During David's presentation, we will have everyone muted. You are welcome to submit comments through the Q&A feature. We will have time for Dave to answer questions at the end. Now, we will turn this over to Dave to start his presentation.
Welcome everyone. A pleasure to talk to you today. I've been working on immigration issues since the 1970s, so I'm familiar with a lot of what's gone on. I am an agricultural economist and not an attorney, so I need to give the caveat here that as we discuss the legislation, I'm not speaking to the legal details. Particularly the problems that individuals confront when they actually try to get legalized in the United States. There are many bars. While the recent bill that we're going to discuss today removes some of those bars, I'm not sure that all of the bars are removed. So, okay, let me get started here. So I'm going to give a little background how we got here. We had the Bracero program, which after deporting about 500,000 Mexicans during the Depression, when we got to World War II, the government realized we didn't have enough farm workers, and so they set up a program in agreement with the Mexican government to bring in Mexican workers. This program was managed by grower organizations, so this is sort of commodity-based grower organizations in the United States. At the peak, there were almost 500,000 Mexican workers in the Bracero program. It was used across the country in cotton, tobacco, sugar beets, fruits and vegetables, but of course, the field crops were mechanized, and so it really came down mainly to fruit and vegetable growers on the West Coast. And it was ended by a group of labor unions and religious groups in 1964. There were a lot of problems with the programs. There have been many books written about it. There was a Texas proviso. Texas was put out of the program at the request of the Mexican government. And wages were stagnant. The government, U.S. government, didn't really increase wages over the 50s. And so that led people to feel like it was displacing farm workers in the United States. But what it did do was it created patterns of migration from Mexico to different places in the United States that once the program ended, people continued to migrate. And this was the beginning of undocumented migration. The National Agricultural Worker Survey says that over half the farm workers in the United States are undocumented immigrants. In California, that number is much higher. So, program, right, exists. It was originally just called the H-2 program and was created to supply temporary seasonal labor to growers on the East Coast, initially for Florida sugarcane, later for New York apples and a variety of different crops along the East Coast. And it was typically 30,000 workers a year for decades. Um, in 86, the Immigration Control Act separated the ag program from the non-ag program. So we got H-2A and H-2B. H-2B has a cap of about 66,000 a year, which is always debated in Congress. But H-2A does not have any cap. It's an uncapped program, right? So you can bring in as many workers as you apply for and the government agrees to. As the current administration has cracked down on the border and migrant crossing, so agriculture has increasingly turned to this H-2A program, and the certifications are now up at around 300,000 or more, has grown very rapidly. And so it's become the main source of labor for a lot of farming in the United States. So the H-2A is a seasonal guest worker program. The workers are mainly from Mexico. There may be some from Central America or the Caribbean. They're assigned to an employer. That is, the employer actually owns the visa, right? And so the workers can't change jobs, right, without some special permission. They don't bring their families, and the visa provides no path to any kind of permanent residency. It's a seasonal worker program. Efforts to have it, year-round workers and so forth have so far not gone anywhere. There have been a lot of studies of abuses, just like in the Bracero program. Varies a lot by what state you're in and where you are. The Department of Labor hasn't been given the resources to really enforce the law. So with the rapid increase in numbers, I can imagine this has only gotten worse. Out here on the West Coast, H-2A workers are employees of farm labor contractors. I think in North Carolina, they're mainly employees of a grower association. And here they work for very large farming operations. I listened to a webinar recently from Washington, and they had a long litany of problems up there of unpaid wages and various things that are typical in all the studies that have been done of H-2A over the years. It stems from the fact that the workers have to pay a recruiter in Mexico to get the job. And so they're reluctant to complain because they need to make money in order to pay the recruiter and go back to Mexico. They're unable to quit the job. They're oftentimes their passport is confiscated, so they have no way to leave. They're stuck there, and they have to do whatever they're told to do. It's not a good situation in many cases. In others, people are treated well, and it's fine. It just really depends. So in 1986, we had the Immigration Reform and Control Act, or IRCA, and this was the last time we legalized a large number of undocumented immigrants. The legislation almost didn't pass, but then this special agricultural worker program was included, and that put it over the finish line. This was the first time when there were any employer sanctions created in law, so you could not knowingly hire undocumented immigrants, but that provision turned out not to really have any effect, right? Because people would come in with fake documents, the employer would look at them, well, it looks good to me. You photocopy them, you put them in the file, and you're done. So that's the way the system has worked pretty much since 1986. Over 1 million people claiming to be farm workers were given green cards as part of this program. And it was, you just had to say you'd worked 90 days in agriculture, have some evidence of it. And there was also a stipulation in this law for a replacement agricultural program, that is a kind of future flow program. But the government found no shortage of ag labor, so the program wasn't started. And then Newt Gingrich and the group of people aligned with him took over the House of Representatives, and they canceled this program. And that was the last time we had any kind of thing other than H-2A for farm workers. I think it's interesting to see that this raw program, as it was written, and required 90 days of ag work from them in each year. Workers could then have applied for a green card. So really 3 years and to a green card. And with 2 more years of ag work, they could have become citizens. So I point this out just because as we get into the current bills, you can see how far we've come from the mindset of this bill. Okay, so Organic Farmers Association voted on an immigration policy. And that policy is here. One, legalize the existing farm labor force. Retain the current H-2A program as it is for those who need it. The people on the coast have argued strenuously. Every time we've gotten into discussions about immigration reform, the H-2A attorneys show up and insist that the H-2A program has to continue. And so it's always included. And 3, add an agriculture work visa program that would require a specified number of years of at-will agricultural work for a specified minimum number of days per year that could lead to a green card if desired. So basically adding in a program for future flow that doesn't exist now. Something where workers could move among jobs and eventually become legal permanent residents. Organic farmers, I think, have a stake in this. Certainly people who grow labor-intensive crops, they're often more labor-intensive than conventional farming because of weeding, fertilizing, pest control issues. And so I work with a lot of organic farmers out here in California, and they have a lot of labor demand. One of the interesting things is that as the H-2A program use has grown out here, workers who are kind of displaced by it, that is undocumented workers, have moved over to other farms. And so the labor shortage seems to have sort of shrunken. All right, so now I'm going to talk. The first is called the Blue Card Bill. And this bill in various forms called ag jobs and different things has been introduced since the late 1990s by Senator Feinstein, who represents California. And this bill essentially attempts to legalize undocumented farm workers. So to get this blue card, the worker would have to show that they had worked at least 100 days over the 2 years prior to the date of act, 100 days a year in agriculture for the previous 2 years, that they have no felonies, they don't have 3 serious misdemeanors, and there's a variety of other things. They have to pay a fine and fees and so forth. But the family would also be eligible to be legalized. And they would have to continue to work in agriculture 100 days a year for 5 years or 150 days a year in 3 years to apply for a green card. So you can see that it looks something like the IRCA replacement agricultural worker thing, where it was 3 years to a green card. Here, you could also get a green card in 3 years. And so in these programs, you're not eligible for what are called means-tested government transfers, that is welfare, all sorts of food stamps, other kinds of things that are basically given to poor people in the United States. And they also aren't eligible for Obamacare subsidies. That's a potential problem in these bills, I think, because what if the workers get sick? I mean, the employers have to cover them with workers' compensation insurance, but that doesn't necessarily just cover illness. So these bills don't really provide a route for workers to have health insurance. you can travel outside the United States once you have this blue card. Uh, it this law doesn't say anything about the H-2A program. It just leaves the H-2A program the way it is. But only Democrats supported this bill when it was introduced. It wasn't a bipartisan bill. And it was introduced in both the Senate and the House. So how does this blue card bill compare to this OFA policy that we voted on? Well, it legalizes the current undocumented farm workers and creates a path to a green card in as little as 3 years. It doesn't touch the H-2A program, so both of those were part of the OFA policy. But it creates no alternative future flow program. And so that means that smaller farms, right, that have a tough time utilizing H-2A would have no source of labor in the future. I mean, the average age of farm workers in the United States, according to the government, is over 40. The farm labor force is aging rapidly. And so figuring out, you know, who's going to do farm work in the future is a really important issue. Okay, so now I'm going to talk about the bill that was introduced. It actually has a number. But I got a copy of it last Friday, and so I'm going to explain to you what it does, and then I will take questions. This bill actually has bipartisan support. And so it has co-authors that are also Republicans, not just Democrats. So it starts by legalizing undocumented farm workers. So it creates a new work visa, which is called Certified Agricultural Workers, or CAWS. So how do you get this visa? Well, you have to show that you worked 180 days over the previous 2 years. So essentially 90 days a year for 2 years before the date that the bill is enacted, right? The bill hasn't been enacted yet. So it would go back 2 years from whenever the bill is acted. Again, like the other bill, no felonies. Here's 2 misdemeanors of a certain type. And again, that you have to have continuous presence in the United States once the bill is enacted, right? So you have to be able to demonstrate that you aren't outside of the country. You apply for this, you get a 5-year renewable dual intent visa, essentially, and your family is included. Out here in California, farm workers are very settled. They mostly have families, and they're mostly undocumented. So at least from our point of view here in California, this would probably legalize a significant number of farm workers. It wouldn't legalize all of them because there are going to be people who have too many misdemeanors, too many drunk driving things, whatever. And so there are other reasons why they might be barred, but it would legalize a lot of people. So once you have this 5-year visa, you can travel outside the United States. Once again, you're not eligible for means-tested transfers or Obamacare subsidies. And to renew for another 5 years, you have to work 100 days a year in ag each year for 5 years, right? So you'd work 5 years. You would have had to been working in agriculture 90 years for 2 years prior to the bill. And then you would have to work 100 days a year in agriculture to go back and renew this visa after 5 years. These workers, because they have to work in agriculture, they're going to be seen by the US government as taking priority over H-2A. So if you use H-2A workers and some CAW worker applied for a job, you would have to hire the CAW worker. They would be considered US workers once they had these visas. Okay, so you have this visa and you want to get legal permanent residency or a green card. So how does that happen? Okay, if you worked at least 100 days a year in ag for the 10 years prior to the act, so 10 years prior to the enactment of this law, and you work 100 days a year in agriculture for 4 years as a CAW worker, then you could apply for a green card. So, but if you worked less than 10 years in ag prior to the enactment of this bill, you would have to work 100 days a year in ag for 8 years in order to apply for a green card. So the worst case scenario is you worked in agriculture for 9 years, and then you're going to have to work another 8 years. So you'd have to work 17 years essentially before you would get a green card. But of course, you'd already worked those 9 years, so it would be just 8 years. But you can see that here, 4 years, 8 years, we've gone up from the earlier bills, right, which were 1 year, 3 years, 5 years, right? So we have longer periods of time that people have to continue to work in order to get a green card. You pay a fine. You have to prove you paid your taxes when you're under this visa, and some of the bars are removed that would normally apply to people. These green cards are not subject to numerical limitations. There are all kinds of limits on numbers of green cards given out to different groups. We give out around 1 million a year in the United States, but these green cards would be exempt from these limits, country limits and job category limits and so forth. The worker has to provide employment records in order to get this visa, and so this law includes a provision that those employment records cannot be used against employers to show that you hired undocumented workers. Undocumented workers who do not qualify for CAW status can have their employer apply for H-2A status for them without needing to leave the country. So this is the provision of, well, what happens to the people who don't qualify, right? The people who had too many misdemeanors or have other kinds of problems. So the provision in this bill is, okay, we'll make you an H-2A worker. But it's unclear to me, you know, what that means here, because H-2A workers are seasonal workers. And they pretty much have to work for one employer and then go back to where they, you know, came from originally. So are we going to make these H-2A workers year-round H-2A workers? I don't know. There's a number of questions that need to be answered here. Then the bill H-2A room. So it creates one electronic platform for all petitions, recruitment, data, worker looking for job, everything. It's all in one electronic platform, right? So you only have to deal with one place as a grower or a worker. It would change the way the adverse effect wage rate is calculated in the H-2A program. There'd be more job categories, and so some wages would be higher and some would be lower. It freezes this adverse effect wage rate for 2020 and limits the increase in future years throughout the 2020s. People have complained that this wage rate has gone up too rapidly, and they don't like the way the government has been calculating it. So, so this is an attempt to try to remedy that. H-2A workers under this bill now become migrant workers, and so they're covered by MISPA, the Migrant and Seasonal Agricultural Work Protection Act, which was passed back in the 1970s and has a whole long list of protections for workers. It requires farm labor contracts to post surety bonds according to the number of workers and wages to be paid. So they've had to post bonds under the H-2A, but it doesn't have to vary by the number of workers and how much wages they pay. So this is an attempt to make sure that there's enough money available should they not pay the workers, that the workers would get paid. And then it creates a provision for year-round H-2A workers. So this has been one of the problems of the H-2A program, is that livestock operations, for instance, couldn't use them. Dairy farm couldn't hire H-2A workers, because they're seasonal workers, whereas a dairy job is a year-round job. So this law allows for 20,000 year-round H-2A workers per year for the first 3 years, and then with some escalator to be decided by the government in the future. So there's some guarantee that there would be up to 60,000 H-2A workers within the first few years who could work year-round. And they reserve half of these visas for the dairy industry if they want them. But of course, year-round employers must provide family housing and also an annual trip for the worker back home to Mexico or Central America or wherever. But it would create a program within H-2A that would allow people who need year-round workers to get them through this program. The visas are issued for 3 years. The workers can come and go. After 3 years, you have to stay outside the United States for 45 days, but that can be reduced based on, annual trips that you take back home for Christmas or things like that. The bill requires recruiters to register with the U.S. government and post a bond, and it tries to rein them in by, having basically some list of who's doing this and so forth. It's against the law for these recruiters to take side payments from the workers, essentially bribes from the workers to get the job, but it happens all the time. And so this is an attempt to try to see if they can stop it. Any grower would, if they determined somebody was doing that, the grower would have to stop using this recruiter. And the bill requires mediation of disputes as opposed to going directly to court. Then there's another provision in the bill which creates a pilot program for a portable H-2A visa. So you can see that everything is being done within the H-2A program, right? If you don't qualify for the CAW visa, you can become an H-2A worker. If you need year-round workers, we're going to create a year-round H-2A program. And now they have a pilot H-2A visa program, 6-year pilot for seasonal H-2A workers. Essentially, the growers would register with, or maybe through this portal that they're going to set up, which is sort of an interagency portal. You'd pay a fee, and then your registration would be good for 3 years, and you'd be able to employ these portable H-2A workers without filing any petition and going through all that paperwork and stuff as at-will employees. So you could lay them off, they could quit, go work for somebody else. The worker has to have an initial job offer from somebody, but then they can leave that job and go to work for other people. So this pilot only contemplates 10,000 workers in this pilot. So it's a pretty small pilot. In California, we have probably 1 million farm workers. So even in California, it's a small thing. But the workers, like I said, can work for any registered employer. And of course, the H-2A, because it's part of the H-2A program, other requirements of H-2A would apply, I imagine, including probably housing, although that's not specified. Green year exempt from country caps for agricultural workers. Right now, there's only about 5,000 green cards, that is legal permanent residency cards, per year for what are called non-professional workers, essentially people who do manual labor and so forth. So we usually around around 2 to 3,000 because it's so difficult for people to qualify for legal permanent residency, given all the different bars that have been put into immigration laws, right? If you entered the country illegally, if you did this, if you have that, and it's just very difficult. Now, employers can sponsor workers through this program for a green card, but it's relatively expensive exercise with your attorney, and it takes time. And then H-2A workers can apply directly after working in H-2A for 100 days a year for 10 years. So now we're up to 10 years here. So if you're an H-2A worker, you work 100 days a year for 10 years, you could apply for legal permanent residency. So once again, everything is being done within the context of this H-2A program. And then the final provision of this law is mandatory E-Verify for agriculture. There have been proposals in Congress to require E-Verify for years. There are several states that do require E-Verify. A couple in the South, I think, and Arizona. If you have agriculture on federal land, I think you have to use E-Verify. And so what it does is you have to basically check the worker against the database to see if they're to be hired. So in this bill, all of ag would have to use E-Verify for all new hires. They would not have to run their existing labor force through E-Verify. So they could continue to employ people who might not have documents or might not qualify for this CAW visa that this bill contemplates. But it's not clear to me, like if you lay the workers off for the winter and they come back, are they new hires or are they not? So E-Verify basically would take effect after the certified ag worker application period. So undocumented workers would apply to become certified ag workers. That would be an 18-month period during which they would be allowed to apply for that. And then 6 to 15 months later, farmers would have to start using E-Verify. 6 months for the largest farms, 15 months for the smallest farms. And finally, the bill authorizes more funding for rural housing programs, since of course H-2A has a housing requirement. I still don't think most small farmers are going to be able to afford to construct housing, which is certainly a problem with utilizing the H-2A program as the framework for all of this. So how does new legal farmer force, right, by giving them these CAW work visas? But there's a long and uncertain path to a green card, right? As long as 8 years if you haven't already been working for 10 years. And it assumes that those who don't qualify become H-2A workers, right? But maybe that's not, convenient for people. Maybe there'll still be a group of undocumented workers out there. So that's a question. It leaves the H-2A program alone, but it streamlines it, makes it more appealing for the growers who use it, right? It moderates wage growth, it makes applying easier, tightens control over recruiters and farm labor contractors. And it has this provision, right, where now we get year-round H-2A workers, right, which will be very appealing, I imagine, to the dairy industry. It created that pilot at-will program within H-2A, but again, there's a long path, 10 years to a green card. And right now, in the initial 6 years, it would only be 10,000 workers. It seems like a very small group to create this at-will program. And that was the kind of program contemplated in the OFA policy statement, right? That workers would be able to change jobs, and then eventually they would be able to get a green card. I don't think we contemplated 10 years and limiting it to 10,000 workers. So that's a question mark. And then there's a bonus of 40,000 green cards per year for agricultural workers, which employers could sponsor the workers for, and which eventually workers could apply themselves for significant numbers. And then mandatory e-verify, that's not something we can contemplated in the OFA policy statement. And it's a potential problem for small farms, as it could limit the labor pool available to them, because H2A is often expensive. They don't have the ability to create housing necessarily. Here in California, housing is extremely expensive to construct, and so, or even to rent. And so it would be a new day if everybody had to provide housing for all their farm workers. So that, concludes my discussion of this bill and how it compares to OFA policy. I think organic farmers often, certainly the people engaged in local food systems and growing specialty crops, have a lot of need for labor, and they need a stable workforce. And oftentimes they rely on people who are settled and have their families. And so this bill does take a step in the right direction in that it would legalize the group of people who are here and their families. And, and it gives people a path to a green card so that eventually people could be settled, even the H2A workers. It's just that the timelines are quite long. And, because farm workers have been getting older and older, right, figuring out how we're going to have a future flow of farm workers seems to me to be the critical question. And so I'm going to stop with that and take some questions. And I don't know exactly how to do that. Here's one. So, how does CAW affect farm workers that are hired to work on a farm year-round? So CAW allows you to work 100 days as a minimum. So it just says you need to work 100 days a year in agriculture. So that's a minimum. So the existing group of farm workers who are undocumented, they get this CAW visa, and then they're just required to work at least 100 days a year. But working more wouldn't speed up your path to a green card at all. Yeah, so it's a minimum requirement. So let's see. I don't see any other questions. Are there any other questions? If so, you should type into the box. Will this make any progress based on where we are with elections? Well, I'm not sure what's meant by that. Obviously, I can't predict whether this bill can pass or not, or whether Trump would sign it. I mean, he's made anti-immigration, right, one of his key platforms. There was Stephen Miller. So are they prepared to legalize undocumented farm workers? I think it's really, really hard to say. Can it pass the Senate? Would Mitch McConnell even take it up? Well, I mean, there is support from Republicans. A lot of farmers are Republicans, but that doesn't mean that we've had immigration reform in the past. So we've tried this over and over again. We tried it in the Bush administration. We've tried it in many different forms since 1986 and haven't been successful. So is this the right moment for it? I don't know. But I think this bill is interesting in that, it starts us on the path to actually trying to solve the farm labor problem. And so whether it can pass this year, maybe it can pass in some future year. Does this new bill with the expanded provisions of H-2A do anything to address the abuses under the current system? Well, like I said, they're trying to rein in the recruiters and to force the contractors and recruiters to post bonds. Be some enforcement at the state level. I think in Washington, people saw there were only a couple people for the state government working on the program. They didn't have a lot of familiarity with it. So the next thing they knew, they had all kinds of illegal things going on. So they tried to pass a bill in the legislature to increase the number of people from the Washington state government working on it. I don't know how that turned out. And so, it really varies from state to state, right? I mean, how involved are the states? The Department of Labor just doesn't have enough resources to really enforce all the rules at all these farms. So some farmers do a really great job, and other farmers or farm labor contractors in particular, take advantage of the situation. If this bill is passed, will it lead to increased wages for farm workers? Since this is all being done in the context of H-2A, if we're going to apply H-2A wages everywhere, then yeah, it would lead to higher wages in states that have low minimum wage. There's a number of states that still use the federal minimum wage, which is $7.25 an hour. So, these adverse effect wage rates are typically $11, $12, $13 an hour. And so it would tend to raise wages in many places. I mean, here in California, we're headed toward a $15 minimum wage. And so it probably wouldn't affect wages that much in California. But because it would provide more labor, it would keep the labor market from driving up wages at least. Anybody else have a question? Oops, here comes one. Do you have a sense if California organic farmers would support this bill? Well, I think the California Farm Bureau and Western Growers, which are both California organizations, have been big participants in creating this bill. I think this pilot at-will program is probably a result of their efforts, as well as the legalization of the undocumented and the 40,000 green cards. I think West Coast, really wants a legal, settled labor force. And so the fact that we're doing it all in the context of the H-2A program is kind of curious to me. But, I think, maybe with some little tweaks to this bill, I think probably California organic farmers would probably support it. The big question mark in my mind is the housing requirement. Housing is just so expensive in California. I just don't know if it's feasible for a lot of smaller or family organic farms in California. So I think that's something to think about. Yeah, so will this be harmful or beneficial to small family-based organic farms? Well, it's obviously a lot more beneficial to large farms than it is to small farms. But in as much as it actually does create a flow of future labor, that could be beneficial to smaller farms. It just all depends on the details of that, what the costs are involved and like the housing. Why is Congress so committed to H-2A? Well, like I said, every time we have an immigration reform negotiation, the H-2A attorneys get themselves at the table. I went to Washington, D.C., and I tried to get myself at the table, and I was rebuffed by David Shahulian, the guy writing this bill. So I'm not going to feel bad suggesting amendments to it. But the H2A people are always there saying, oh, we got to have H2A, blah, blah, blah. And I think as more and more people have come to use H2A, there's become a bigger constituency for it. And so I think that's why the bill is written in that kind of context. The program exists. It's acceptable to Congress, obviously. So we'll just, make these tweaks to it in some way. Here's a question. What if someone is already here, undocumented, and has worked for many years? I imagine they are not eligible for H2A. So in this bill, there are provisions, right, for these people. If you're here and you're undocumented, you can apply for this CAW visa, Certified Ag Worker visa. If you don't qualify for that visa, then they allow you to apply to be an H2A worker. So all undocumented farm workers would have a path to some legal visa. Then whether you are going to continue working in agriculture for the required number of years, whether it's 4 or 8 or 10, it would be really up to the worker. But yes, everybody who's here and is an undocumented farm worker under this bill would have some path to a legal visa. Let's see. Any other questions? If not, we can wind this up. People there at OFA, maybe you want to take it back over again. I don't know how we're going to wind this up.
Absolutely. Thank you, Dave. I think that concludes all of our questions. I wanted to thank everyone who joined today. And I also wanted to mention that Dave is also a member of OFA's policy committee. So we really appreciate his dedication to the work on such important topics. You can also register for upcoming webinars on our website at organicfarmersassociation.org. A few of the topics include the organic dairy crisis, hydroponics, and import fraud. So we encourage all of you to join for those as well. And OFA is also a membership organization. So we invite you to join as either a farmer member, a supporter member, or an organization if you are not already one. And we just really encourage you to be a part of this really important national movement. And any additional information can be found on our website as well. We will also send you a link to the recording of this webinar, and we encourage you to share it with any of your friends and family as well. So thank you all again for joining, and we hope you are able to be a part of some of our future webinars. And thank you again to Dave.
Yeah, thank you.